When your lordship say that there is no jurisdiction, a regular bench might, in the exercise of judicial power, come to the same conclusion, that it cannot hear the case because 191A has been validly enacted and it divests me of jurisdiction, but not judicial power. That is inherent in a court. Let me read a passage from Ziaur
ये
Rahman.
चीज और भी ऐड कर लीजिए इसमें, because you are going to argue on that point. In the District Bar Association case, there was simple amendment in the constitution where the military courts were given jurisdiction for 2 years, then it was extended for further years, and the constitution amendment was protected just because of there is a sunset clause. But in that District Bar Association case, the Supreme Court was the only Supreme Court. There was no constitutional bench. Okay, so if had there any 191A at that time, then obviously the Supreme Court had to do something, and how to wriggle out from that provision. That was not available at that time. But here there is 191A. There is totally different case of District Bar Association before us, because you have to pave the way for us to make the full court, and you have to prove the solution, how we can move forward. Just because of District Bar Association, in my own view, that was not the situation which we are facing now.
Kindly
Adding to that question, suppose if we pass order of full court, whether that would be called constitutional bench or it would be simple.
No, because my submission is that Article 191A does not denude the Supreme Court of jurisdiction. All it says is if you form benches, then bench A cannot hear a constitutional case, bench B can hear a constitutional case. It does not say that the Supreme Court cannot hear that case. That is my submission. Now kindly read with me a passage from Ziaur Rahman's case. It will bring my submission into greater focus.
What is this
This is
citation?
PLD 1973 Supreme Court, page 49, which it acquires not divorce the Constitution, but by virtue of the fact that it is a superior court set up by the Constitution itself. It is not necessary for this purpose to invoke any divine or supernatural right. But this judicial power is inherent in the court itself. It flows from the fact that it is a constitutional court, and it can only be taken away by abolishing the court itself. In saying this, however, I should make it...
Sorry, this is a right. This is a right. What is the right is the previous paragraph. अगर आप वहाँ से पढ़ लेते ना तो it
जी
would
जी
be
वो
more easy for us to
उसमें ये है
understand the dictum laid down by this court.
जी जी जी
यहाँ से पढ़ी ना, so far therefore.
So far, therefore, as this court is concerned, it has never claimed to be above the Constitution, nor to have the right to strike down any provision of the Constitution. It has accepted the position that it is a creature of the Constitution, that it derives its powers and jurisdictions from the Constitution, and that it will confine itself within the limits set by the Constitution, which it has taken oath to protect and preserve. But it does claim, and has always claimed, that it has the right to interpret the Constitution and to say as to what a particular provision of the Constitution means or does not mean, even if that particular provision is a provision seeking to oust the jurisdiction of this court.
ठीक है, अब पढ़िए. This is the right.
Ji. This is the right which it acquires not divorce the Constitution, but by virtue of the fact that it is a superior court set up by the Constitution itself. It is not necessary for this purpose to invoke any divine or supernatural right, but this judicial power is inherent in the court itself. It flows from the fact that it is a constitutional court, and it can only be taken away by abolishing the court itself. Now Article 176 is still there.
No, don't you think that Article 191A has taken away jurisdiction of rest of
It
the
may have taken away jurisdiction, but what I am saying is that the judicial power to decide whether that jurisdiction has been taken away or not, it still remains with even the regular benches and the full Supreme Court, because
No,
judicial...
it has only demarcated abrogated the jurisdiction of regular bench and the constitutional bench,
Yes.
it does not mean abolishing the Supreme Court itself.
Yes, it does not. Once there is a Supreme Court, then it has the inherent right to exercise judicial power in the trichotomy of powers. That is the system that we have. And once the only repository of judicial power is the Supreme Court or is the Constitutional Court, then it has the right to decide whether it has the jurisdiction or it doesn't have the jurisdiction. Supposing the full court comes to the conclusion, the Supreme Court comes to the conclusion that, oh, we can't hear it as a full court, it has to go to the constitutional bench. The power to decide still remains with the Supreme Court, the full court. I shouldn't be using the term full court. It is the Supreme Court. This is just a carving out of a division or a jurisdiction. In all the constitutional documents, starting from 1935 till 1973, prior to the chapter on the Federal Shariat Court that was brought into the 1973 Constitution, the word bench is alien to the Constitution except one place. That one place is the interim Constitution of 1972, in which it was pursuant to the dissolution of the West Pakistan High Court that there were permanent seats. There was a principal seat at Lahore and permanent seats at Karachi and Peshawar. So when the 73 Constitution came in and there were these 4 provinces, there was no longer, pursuant to the dissolution of West Pakistan order, there was no longer the West Pakistan High Court. Those judges that were at the permanent seat at Lahore became judges of the Lahore High Court. Those who were at the permanent seat at Peshawar became judges of the Peshawar High Court. And similarly, the Sindh High Court from Karachi. In one article, the word permanent bench was used. But those were benches on those seats which could not be disturbed without consent. Your Lordship knows when we were arguing the Razfar case. So, this concept of a bench was for the first time introduced when the Federal Shariat Court was created. That is when the Shariat Appellate Bench of this court was constituted. And the Constitution, Article 203, is very explicit that this jurisdiction shall only be exercised by the Shariat Appellate Bench. There is no such exclusion in Article 191A. Now, my lords, your lordships are the Supreme Court.
एक बात इसमें और कर लें. देखिए,